John Marshall is our fourth Chief Justice and possibly our most famous Chief Justice. Well, he is someone who's responsible for the Supreme Court taking on the form that it currently has. At the founding, when each of the justices would issue their opinions, these opinions were issued seriatim, or one after the other. What an opinion was the justice's justification for how the justice voted. So if you had 5 justices, or 6 justices, as they had back then, you had 6 opinions. It was John Marshall that was able to implement what's called the opinion of the court. So now the court is speaking with supposedly one voice, and in Marshall's case, it was typically an opinion written by himself. And it was ever since that day until this day that Supreme Court opinions started to be studied as though they were the law. The words of the court were being parsed like a statute is supposed to be parsed. And that has profoundly affected how the Supreme Court is viewed relative to the other branches. Marshall was a high Federalist, which means he was a nationalist in Alexander Hamilton's mold. He was a disciple or a protege of Alexander Hamilton, who looked up to him. And so a lot of what his agenda was pursuing and reinforcing the existence of a strong national government at a time when there was, as there always has been, political pushback against a strong central government. The Supreme Court would have been quite different if justices continued to issue their opinions on their own. So if every justice issued his or her own opinion, that would look quite different than having an opinion of the court. Why would that be? Because what other agencies of government would have then to follow is just the outcome of the case and the rationale that would justify that outcome as explained by various justices. What we would not have are opinions of the court that could then be parsed and followed like statutes. And having opinions of the court has elevated the Supreme Court in a way that previous practice before John Marshall would not have done. Marshall might be surprised, like I think all Supreme Court justices would be surprised by how prestigious the job of a Supreme Court justice is. I mean, we had previous Supreme Court justices like John Jay, our first Chief Justice, who basically left the office because it was not significant enough. He wanted to go on and do bigger things than be Chief Justice of the United States. So I think that would be one of the things. I suppose another thing that would surprise him is that the title of the Chief Justice is now Chief Justice of the United States. At the time he was Chief Justice, the title was Chief Justice of the Supreme Court. That title was changed when Salmon P. Chase became Chief Justice. If you ask John Roberts what he knows about Salmon P. Chase, the first thing that he knows about Salmon P. Chase is that the title that John Roberts, has is due to Chase. I think I'd like to discuss with him his opinion in McCulloch versus Maryland, because McCulloch versus Maryland has been used as the basis for the modern administrative welfare state ever since the New Deal. Our post-New Deal constitutional understanding has been based on McCulloch versus Maryland, but I don't know that it's been based on an accurate reading of McCulloch versus Maryland. So the first thing I would like to ask him is, does he share the contemporary interpretation of McCulloch that is being used to justify a vast federal power? I think what Marshall was trying to do was to allow Congress a considerable amount of power in deciding what means it may adopt in order to pursue a constitutionally permissible end. But what he was not trying to do was give Congress a blank check with respect to those means, which is in fact what the Congress now has as a result of New Deal Supreme Court opinions that essentially undid at least a part of McCulloch versus Maryland while attempting to follow it. The part that it purported to follow was John Marshall's famous statement, that the word necessary in the necessary and proper clause does not mean strictly, logically, or absolutely necessary. And I think he was, by the way, right about that. He then used a string of synonyms to describe what necessary meant. The last one of that one, which was convenient. That was basically the problematic word that he used. And so that meant that Congress had a lot of discretion in figuring out what was convenient or not. And this was the part of Marshall's opinion that President Madison, who had signed the bill that Marshall was upholding into law, took issue with. In fact, Madison complained not only about the use of the word convenient, because he said with that as the standard by what can give the courts any sort of hold or purchase on the case. He also objected to the lack of seriatim opinions I mentioned before. He thought he'd like to hear what the other justices had to say, not just what John Marshall had to say. So that was part of it. But there's a very important part of McCulloch that actually gets reversed sub silentio by the Supreme Court. And that's where Marshall says, should Congress, under the pretext of exercising one of the powers that it was given, in fact exercise a power that was not given to Congress, it would become the painful duty of this tribunal to say that such an act was not the law of the land. Mm-hmm. So that statement, first of all, it distinguishes between a legislative act and what is truly a law. And something that is not truly a law is something that is beyond the powers of Congress to enact. And it is beyond the power of Congress to purport to be using one of its enumerated powers, but in reality, that's merely a pretext, and it's actually exercising a power that was not delegated to it. That was a very important part of McCulloch versus Maryland. When Marshall went to defend himself from vehement criticism that was being published in newspapers in Virginia of that opinion, and he went to defend himself anonymously writing op-eds in Virginia newspapers, he cited that passage in defense of his own opinion, saying, well, they didn't give Congress an unlimited power. But the New Deal Court basically reversed that part of McCulloch versus Maryland when it said in Darby v. U.S. That the court would not inquire into the motives of the legislature. As long as the legislature was purporting to be exercising one of its powers, it would take it at its word. Well, that is not what Marshall says in McCulloch versus Maryland. What Marshall says is he would not take him at its word if, in fact, Congress was acting pretextually. I don't know of another example where it happened. On the other hand, those were the days when pseudonymous essays published in newspapers were all the rage. I mean, the Federalist Papers were published under the name of Publius. No one was sure who wrote them, and even to this day there was some controversy about which person authored which Federalist paper. And so it was not that uncommon to defend yourself or to attack using a pseudonym. He was attacked under pseudonyms by someone like Spencer Rowan, who was a Virginia judge himself. But it was very uncommon, and it was clear that the reasoning of McCulloch versus Maryland raised a firestorm that Marshall decided it was in his interest to try to put out. Our federalism, in the beginning, depended on the federal government, the national government, and Congress in particular being one of limited and enumerated powers, which would then leave all other powers to the states. And as soon as you gave Congress unlimited powers, then that means all other powers would not be left to the states, and our federalism would be undermined by a strong national Congress that could do whatever it wants, which is more or less what we have today, with some very, very out of limits that are pretty far out there. So that was what was at stake, and a lot of it turned on, first of all, this use of the word convenient, which is a word that Hamilton himself had used, which Marshall basically cribbed most of McCulloch from Hamilton's written defense of the National Bank when he was in Washington's administration. And secondly, that was the main thing that was at issue there, and so what became at issue later is the taking out of the opinion Marshall's qualification to what he had said. The Bank of the United States was very unpopular in the beginning. And Jefferson, when he was in the Washington administration as Secretary of State, wrote an opinion saying it was unconstitutional because there was a big fear that the bank represented what you might call establishment money, the moneyed classes, as opposed to the agrarian classes or other classes that might exist. And so banks were a politically salient issue, maybe the most. Having a national bank may be the most politically salient issue that haunted the first 20 or 30 years of the country. But as there were economic upturns and downturns, people like Madison, for example, started to see the utility of banks, where when it was being first proposed, they hadn't had one, and they didn't know whether they'd be useful or not. So Madison signs the bank bill into law. because I think by this time, even Madison, who was a close ally with Jefferson, saw a bank as potentially necessary. In fact, that's how he justified his signature on the bank bill, which he says that it would be presumptuous of him, after seeing banks being accepted by Congresses in the past, and given, he said, the almost necessity of them, they're almost necessary, it would be presumptuous of him to veto the bill. And he signed the bill. That's how he defended himself. But I think one thinks that by this time, the politics of the bank were different than they were at the very, very beginning. Andrew Jackson, Madison's successor, he vetoed the renewal of the bank on the grounds that it was not necessary. Again, all about what is the meaning of necessary and proper. And what Jackson said about why he could do this, even notwithstanding McCulloch versus Maryland, was he said, look, what McCulloch versus Maryland says is it's up to the legislature to decide essentially what's necessary or not. And when I exercise my veto power, that's a legislative power, so the president is really part of the legislative process. And therefore, it's up to me as to whether I think it's necessary or not. And because I think it's not necessary, then it's also not constitutional, because it's not necessary under the necessary and proper clause if I think it's not necessary. And McCulloch versus Maryland basically says that the Supreme Court needs to defer to us, and so I say it's not necessary. Well, he most famously said that the power to tax is the power to destroy. And what was at issue here was the power of the state of Maryland to tax a U.S. entity like a bank. And the thinking is that if Maryland could tax a bank, it could put the bank out of business by a prohibitive or punitive tax, which I think is probably something that any tax could be used for if you did it that way. There is some thinking that the Bank of the United States was not an agency of the government of the United States. It was authorized. It was a private institution, a private stockholding institution authorized by the government of the United States to hold a monopoly. That's what made it constitutionally dubious, because it had a monopoly aspect in certain ways. There's some thinking that a local or state tax that taxed all banks equally and did not discriminate against the Bank of the United States should not have been unconstitutional. He rules the other way because he thinks this is a tax aimed at the bank. And again, this goes to, in some respects, the motives of Maryland. Remember, I said earlier that he said if Congress, under the pretext of exercising one of its powers, really exercises a power it should not have, it would be the painful duty of this tribunal to say that such was not the law of the land. The same thing would hold true of Maryland. If under its general power to tax, it actually uses its tax power to undercut a federal institution, that also is an improper motive for how it's exercising its tax power. The important part of this aspect of McCulloch, but it's not only McCulloch, it's other opinions by Marshall as well, and that is that the federal government is not a creature of the states, which is something the Anti-Federalists said, which is something that Democrats or Republicans and then eventually Democrats also said, and that is that and in fact it's said today, that the federal government is a product of the states, like the states got together and created a federal government. Marshall, and along with other Federalists and other nationalists at the time, but even people who were not nationalists like Madison, denied that. They said that no. If it had been a creature of the states, like the Articles of Confederation was, then state legislatures would have ratified it. Because then it would have been the state governments that ratified the Constitution. But that's not the ratification procedure that the founders used. They went back to the people in the form of conventions. And conventions, by the political theory of the day, were the way the people in England as well as the United States would exercise their own voice. And so, according to this theory, and it's a political theory, it was not the states that ratified the Constitution. It was the people of each state that decided whether to join the Union or not. Now, the people of each state could decide not to join the Union, and then they wouldn't join it, because nobody could be brought into the Union except by their consent. The Constitution would start if 3/4 of the states agreed to it, but no state that refused to agree to it would be bound by it. So Rhode Island was out in the beginning, and North Carolina was out in the beginning. They didn't get in until they got in. But nevertheless, the idea here is that it was the people of each state that ratified the Constitution. Therefore, it was a creature of the people. And the states were, so some of the sovereignty of states were withdrawn by the people and then handed over to the federal government, who exercised power over the people directly and did not have to work through the states the way the federal government did under the Articles of Confederation. It's an aspect of the federalism that was adopted at the founding, which was the great compromise between a nationalist government and a Articles of Confederation treaty or League of States. It was where sovereignty gets divided between two separate entities, rather novelly, between the federal government, who has partial sovereignty, and the state governments, who has another partial sovereignty, and other sovereignty retained by the people. So I would not say it's a nationalist vision. I would say it is the federalist, the original federalism vision. A true nationalist, or what was then called a consolidationist, was somebody who aspired to have one national government. And the states, if they were to continue to exist at all, would simply be subunits of a national government. And we didn't have that at the founding. We don't have it yet. There is a lot of movement since the New Deal that gets us closer and closer to that, but we're not all the way there. We still have a system in which states have their own powers and the federal government has their own powers. This does rely on the Supreme Court being able to draw that line, and since the New Deal, they've been reluctant to do so. But it is a line that Marshall identified here, and he identified it also in the case of Gibbons versus Ogden. Gibbons versus Ogden is about whether the state of New York can grant a monopoly to a shipping company that takes passengers from New York to New Jersey. Ogden is the one that holds the monopoly. Gibbons is the person who is challenging the monopoly because he has a license from the federal government, and under a national coasting law. It was called coasting. And so the question is, which takes priority, the national coasting law passed by Congress or a local monopoly? And what Gibbons versus Ogden is about whether the national coasting law is constitutional under the commerce power, which says Congress shall have power to regulate commerce with foreign nations among the several states and with Indian tribes. The scope of that power is what's at issue in Gibbons versus Ogden. And the number one question is navigation within the commerce power? And the short answer to that is it was within the commerce power. Then the question is, why is it within the commerce power? Is it part of the original meaning of commerce itself? Or is navigation something you regulate because it's a means of regulating what is otherwise commerce? And my research has suggested that was within the core meaning of commerce itself. That is, commerce meant the sale, exchange, trade, barter, transportation, and movement of things or people from one place to another. And the activity of commerce was distinguished from the activities of manufacturing, which you make stuff, or agriculture, in which you grow stuff, or husbandry, in which you raise animals. These were all distinct economic activities, distinct from commerce. Commerce was the movement, the sale, trade of all of those things. So I think it's pretty plain to me that commerce included navigation. So in that sense, Gibbons was absolutely rightly decided, and Marshall was correct to say that Congress had the power to regulate the coasting trade, which was navigation up and down and on the coast or through navigable waters. That's what was at stake. But in the course of doing that, Marshall adopted, shall we say, loose or capacious language that could be exploited later on to claim that Congress had a far broader power than merely the power over navigation. That gives rise to the issue of what's called the Dormant Commerce Clause, and that is whether the granting of the right to regulate commerce between the states to Congress precludes states from regulating that same activity before Congress has the opportunity to regulate it, and therefore, or it's referred to as commerce in its dormant state. It is a commerce power in its dormant state. It hasn't been exercised yet, and states may not interfere with it. That is a controversial claim from that day until this date as to whether the commerce power really has that effect. Or, alternatively, does Congress need to exercise the power in order to have the power? That is, states can't have a law inconsistent with an act of Congress, but states can have laws that are not inconsistent with acts of Congress. It's up to Congress to act. That's really what the debate is about. And Gibbons doesn't clearly raise this debate because Congress had passed a law, and the issue was whether that law was consistent or compatible with the New York monopoly. My biggest criticism of Marshall as a justice is he uses language to define other language, and the terms he uses to define other terms can be interpreted quite capaciously, and then they were. So, for example, in McCulloch versus Maryland, he has a string of synonyms for necessary, one of which is convenient. Then, by the way, when he goes to defend himself from claiming that the court has sanctioned delegating all power to Congress or deferring to Congress, he says, no, he didn't use the word convenient, but he did use the word convenient. So he quotes a different part of the opinion that doesn't use the word convenient. But he did use the word convenient. Well, convenient meant something pretty capacious, which is why Madison objected to it. Similarly, in Gibbons, when he asks, well, what is the meaning of commerce among the several states, he says it means commerce that affects more states than one. Well, commerce among the several states doesn't necessarily mean that. Commerce, the most natural meaning of commerce among the several states is it's commerce between the states. Now, you and I, when we're talking, if we're talking about between two things, we say between. If we're saying between three or more things, we say among. We use the word among rather than between. And in fact, when Hamilton, in his earlier essay on his report on trade, uses the word, refers to the commerce power, he talks about commerce between the states. It clearly was commerce that took place between one state or another. But if you substitute for that, Congress that affects more states than one, well, is activity, then lots of things can affect more states than one. So one of the big ways in which federal power was increased after the New Deal was what is called the substantial effects doctrine. And that gives Congress the power not only to regulate commerce between states, but to regulate any other activity or perhaps economic activity that has a substantial effect on commerce between the states. Well, where did that effect language come from? It could be found in Marshall. It can be found in Gibbons versus Ogden. Now, whether Marshall intended to authorize such a broad, capacious power is an open question. It's undermined by the fact that in Gibbons he also identifies what the broad powers of states are, which includes the regulation, health and welfare laws of every description. These are within the police power of states. So he actually identifies very broad state powers. So you can read Gibbons as a conventional federalist opinion, but he picks words that can later on be used to expand federal power and claim that they are doing so consistently with the original meaning of the Constitution, not because that's what the founders thought, but that's what John Marshall said in these capacious opinions of the court. It seems to be a pattern of his to use flowery synonyms, capacious synonyms that were either incautious or they were deliberate. And I'm prepared to say, I don't know whether they were incautious or deliberate, but I'm prepared to say they were incautious, and they've proven to be so. Marbury wants his commission to be a local justice of the peace. And what happened to his commission? Well, it's a very curious story about what happened to his commission. Marbury was given his commission by President Adams on his way out the door as he's about to vacate the presidency for Thomas Jefferson coming in as the new president. And he was appointed as one of what was called the Midnight Judges because they were authorized by an outgoing Federalist Congress, a lame duck Federalist Congress, and made these appointments by a lame duck president. And these commissions had to then be distributed or delivered to the recipients. And who was responsible for the delivery of these commissions? Well, it was John Marshall, who at the time was basically holding two offices at the same time. He was both the newly confirmed Chief Justice of the Supreme Court, now we call him Chief Justice of the United States, and he was the Secretary of State. in the Adams administration. So as Secretary of State, he and his brother were supposed to get up and deliver these commissions, and they rounded up a whole bunch of them, but they left Marbury's behind. And as a result, his commission did not get delivered. And it was Marshall who was responsible for that. Well, Jefferson's position and the position of the administration was that it could be revoked. In fact, when the Republicans came in, they repealed the Midnight Justices law. They also suspended the jurisdiction of the Supreme Court, the term of the Supreme Court, for a year. And so the Supreme Court didn't even sit for a year as a result of their actions, not wanting the court to get involved in all of this. And he argued that a commission that wasn't delivered is actually has not been completed, it has not been perfected, and therefore he's not entitled to it. Marbury versus Madison is a very complicated ruling, and it's difficult to teach it. And you can actually spend a whole classroom just trying to figure out the facts of what happens. So the most important thing, I think, to know is that he holds unconstitutional the Judiciary Act, which purported to give the Supreme Court the right or power to order the president to deliver the commission. And because that part of the act was deemed to be unconstitutional, he said the Supreme Court was powerless to order the president, or in this case it was Madison, who was the new Secretary of State, is James Madison, to order James Madison to deliver the commission that he, Marshall, had failed to deliver. Why? Because the Supreme Court did not have that power constitutionally. Congress gave him the power, gave the Supreme Court the power, but that was unconstitutional. And what's considered to be so clever about this is that it allowed Marshall and the Supreme Court to invalidate a federal law in such a way that the Jefferson administration could not challenge and disobey. So if Marshall said, well, you must do something, and Jefferson said, well, I refuse to do it, now make me, that would have created a constitutional crisis. But what Marshall did instead was said, no, we have the power to invalidate a federal law, and as a result of that, unfortunately, we cannot order you to do anything. So we cannot order you to do anything. Marshall did not invent judicial review. First of all, the word judicial review is anachronistic. It wasn't used at the time. In fact, it didn't come into common use until the 20th century. The issue is really whether judges had the power to nullify laws, or actually whether judges had whether judges had the duty to follow the higher law of the Constitution rather than an inferior law, which was a mere statute. That relationship between the higher law of the Constitution and a mere statute was identified by Alexander Hamilton in Federalist 78. It was a relatively common practice for courts to feel they had this power, and the Supreme Court itself had said it had that power prior to Marbury versus Madison. So Marbury versus Madison did not invent the power. The power was thought to exist, and it was said to exist by the Supreme Court. What makes Marbury different is that it's the first time the Supreme Court uses the power to invalidate a federal law. It's merely the first time the power is used. It's not the first time the power is spoken of or defended. And after Marbury, Marbury was not considered to be a very important case. It was not famous. What made Marbury famous were the progressives in the 20th century, because the progressives were against judicial review, and they argued against judicial review. And it was in their interest to say that this doctrine, judicial review, well, you don't find it anywhere in the Constitution, and you just find it in this case, Marbury versus Madison, which was some years after the Constitution, and John Marshall just made it up. So they were using Marbury versus Madison and the claim that Marshall had made up judicial review as a way of undermining the legitimacy of judicial review. That was a claim that was basically promoted by progressives, and it was taken up by modern political conservatives after the New Deal. And so you still hear that claim being made by many, many conservatives today, even though it's historically false. The term that was used by him in Marbury and by Hamilton in Federal 78 was duty, not power. If you think about it, there's a big difference between a duty to follow the law and a power to invalidate a law. Why? What's the difference? Well, if you have a duty to do something, you really don't have any option. You have to do it. If you have a duty to your children, you have to honor your duties. A duty to your employer, you have to honor your duties. If you have a power, well, powers can be exercised and should be exercised with discretion. So by switching it from a duty to follow the law, which law? The higher law, that law of the Constitution, as opposed to a lower law of the statute. By changing it from a duty to follow the higher law to a power to invalidate a lower law, you introduce a degree of discretion and choice. And then what you introduce is the concept of judicial self-restraint. Judges should be self-restrained in exercising their powers with respect to the other branches of government. The Supreme Court is the highest law of the land, and when a case properly comes before the court, which is how he puts it, when a case is properly before the court, why? Because there's an actual case in controversy between two parties who have what we would today call standing. When a case is properly before the court, the Supreme Court is the highest court in a hierarchical system to say what is the law of the land and apply that to the facts of the case in front of them. So if you properly construe what Marshall was doing, I think Marshall was correct. Now, you can construe Marshall as doing more than I think Marshall was doing, which argues somehow the Supreme Court is the boss of the whole system. But I don't think that's what Marshall was really saying. He's saying that when a case properly comes before the court, it's up to the court to say what the law is, and not necessarily to defer to some other branch's vision of what the law is. But only with respect to cases that are properly before the court. They decide cases in front of them. It's not something that they necessarily can order about all other government actors and say everybody else must act the way we say you must. Well, I think it's relatively easy to say, especially given what he does in Marbury, that Marshall would not have reached the issue of whether the Missouri Compromise was constitutional or not, because if he was going to agree at all with what the court was saying, he would say that Dred Scott didn't have standing to bring a lawsuit in federal court. Taney went beyond his own holding in the case to actually reach out and decide a case that presumably he had no jurisdiction to decide because he'd already said that Dred Scott lacked standing to be in front of the court. Now, I don't have any idea as to whether Marshall would agree with Taney that African Americans couldn't possibly be citizens of the United States. I think it's unlikely that Marshall would agree with that, in part because that was not a prevalent understanding at the time of the founding. That was something that came about later. So it's something that Taney was talking about, but I don't think he was right to attribute those views to the founding and therefore not right to attribute those views to Marshall. All I'm saying is that if he were to agree with Taney about that part, he never would have reached the issue of the Missouri Compromise because he would have said, we're out of here. We don't have jurisdiction. But Taney was looking for the opportunity to make a ruling to supposedly settle this slavery question, which had the opposite effect. And I don't know that Marshall would have had that sensibility. And most of the Virginians were quite reticent about trying to say too much about slavery because they understood that slavery was incompatible with the Declaration of Independence. And so therefore they always liked to punt and to defer and to avoid. They didn't want to directly confront. That was a mindset that didn't arise until well after the founding. Well, I can't say that he's my least favorite justice amongst all the famous justices. Of course, there's all the obscure justices we have no opinions about. But of all the famous justices, I can't say he's my least favorite one, but he is among my least favorite ones, primarily because I think, first of all, he did share perhaps a more nationalist vision of the Constitution that I think is justified, but also because he wrote in such a capacious way that he opened the door for interpretations of the Constitution that either he intended, in which case he was wrong, or he didn't intend, in which case he was careless. And for that reason, he's not one of my favorite justices. And I'm also not a big fan of opinions of the court, which was his great innovation to make the Supreme Court essentially a maker of law rather than a follower of law. And so for both of those reasons, I'm not a big fan.